Welcome everybody to the Health Law and Ethics Network May seminar. I'd like to start by acknowledging that the Melbourne Law School stands on the lands of the Wurundjeri people and pay my respects to elders past and present and emerging, and to acknowledge any Indigenous colleagues here today. We're very pleased to welcome you here for the May seminar. My name's Professor Paula O'Brien from Melbourne Law School. I'm one of the directors of the Health Law and Ethics Network. I'm joined by my co-director, Chris Gingell, at the front here. And we're very pleased to welcome our colleagues, Bill Madden and Tina Cockburn, to give the lecture today. So the presentation today is about secondary victim mental harm claims following negligent medical treatment, a change in direction. And we're so pleased to be able to have Tina and Bill talking to us about this topic today. Negligence and compensation for mental harm is a very important topic in Australia. And Tina and Bill are true experts in the field, so it's quite a privilege to have you both here today. Bill is here teaching medical litigation in the Melbourne Law Masters, so a special welcome to all of Bill's students who are joining us. And we hope that it will be a great seminar today. Bill and Tina will talk for about 40 minutes with some time for Q&A, but Bill's also said that they're happy if you have some questions along the way, and if it's appropriate, they'll stop and answer the questions. Just to, for those who don't know Bill and Tina, just to let you know, so Bill is a lawyer in private practice. He's an adjunct professor at the Australian Centre for Health Law Research at Queensland University of Technology, and also a senior fellow in the Melbourne Law Masters. And Professor Tina Cockburn is a professor in the Faculty of Business and Law at the Queensland University of Technology, and she's also the director of the Australian Centre for Health Law Research. So thank you very much, Bill and Tina, for joining us today. And I'll hand over to Tina now. Thank you, Tina.
Good afternoon, everyone, and thank you very much for inviting us to speak here today. I too would like to acknowledge the traditional owners of the lands on which we're meeting and pay respects to elders past, present and emerging, and acknowledge that these lands have always been places of teaching, research and learning. Thank you again for inviting us to talk. This area of compensation for mental harm has created a lot of interest and uncertainty, and actually attention of the courts over many years. In 1999, Donald Nolan, an academic colleague from the UK, said that all that's certain now is that the law on nervous shock in the United Kingdom is a shocking mess. Complexity and confusion are the order of the day, and in their wake comes inconsistency and therefore injustice. In Frost, that's one of the leading cases, the current House of Lords made it clear that rather than clearing the mess up, they were content to push it around the floor. Any serious cleanup must now be done by Parliament. For those who have to try and pick up their way through the clutter, the nightmare continues. And I think that's really true to say. The nightmare is continuing with the recent decision in Paul in the United Kingdom. It was most certainly for victims of, secondary victims of medical negligence. So what we thought we'd do today is provide an overview of that recent English decision and the context in which the decision was decided. And then we'll revisit the Australian common law position as amended by the civil liability legislation. And then Bill's got some challenges for you to have a think about and see what your thoughts are on how the courts might decide some novel cases here in Australia, in particular, whether the recent English decision might mean that a different or perhaps a more cautious approach might be adopted in the Australian context. So the question really that came before the court in Paul's case was whether a secondary victim, that is not the primary victim, being family members most usually, who witnesses the death of a close relative as a result of medical negligence and subsequently suffers psychiatric harm, is entitled to compensation. And really what goes on in these cases is the courts are struggling with balancing, compassion and providing compensation to those who are injured as a result of medical negligence, and also avoiding the floodgates of open-ended liability, which of course has economic and social consequences. So the question is, what are the control mechanisms and where do we draw the line in terms of recovery? So in England, the claims for psychiatric injury have come to be categorised as either primary or secondary victims' claims based on the critical issue of whether the plaintiff was a participant in the incident, that is a direct victim really, as opposed to a non-participant in the sense of being a passive witness to the death, injury or impediment of another person. And the question then, of course, becomes, should there be a different approach taken to recovery? And in England, most certainly, that categorisation as either a primary victim or a secondary victim has actually significant consequences in terms of recovery, because for secondary victims, the way that the courts have regulated recovery has been to introduce control mechanisms known as the ACHLR conditions on recovery. And those prerequisites include whether there's a close tie of love and affection between the primary victim and the secondary victim, whether the claimant, that is the secondary victim, was close to the accident in time and space, and also whether that claimant directly perceived the accident rather than, for example, hearing about it from a third person. And another limiting factor was also developed in the sense that only people of normal fortitude were allowed to recover. So those prerequisites developed in the context of road accident cases, and also the Hillsborough Stadium disaster, where the police let too many people into the stadium and a horrific accident happened. People were killed and injured, and a lot of people obviously witnessed that, family members that were there, people saw it on TV. And you can also think of other examples in our modern times where that sort of accident and witnessing of the accident and the aftermath might occur. And the question really then becomes, can those people who are not the direct victims recover for the psychiatric injury that they may develop as a result of seeing the accident or seeing the aftermath? So Bill's done this beautiful diagram. So the patient, in the context of medical negligence, the patient would be the primary victim who has suffered injury as a consequence of medical negligence. In the cases that we've been looking at, most of the time, sadly, the patient dies, and then the question becomes, can their relatives recover for the psychiatric injury that some people develop as a result of seeing that intense suffering of their loved one? So that distinction between primary, and in England most particularly, the distinction between primary and secondary victims is quite critical. And as I said, the courts have developed those control mechanisms. So in its first decision in 2024, the United Kingdom Supreme Court was asked to answer this direct question. Could a secondary victim make a claim for psychiatric injury, mental harm caused by witnessing the death or the horrifying event of a close relative as a result of medical negligence? The short answer, getting straight to the conclusion in the case, was that the UK Supreme Court said that those claims are no longer available. They're not available, except there is an exception, perhaps, in cases where the claimant, being the family member, was present at the time of the medical treatment, because you might be able to categorise the medical treatment as an accident, and then you can satisfy all the other requirements being, present at the time. I'll explain that further in a moment. The point really is, and Bill's going to talk some more about this, is that in Australia, the law allows recovery really if there's reasonable foreseeability, and other factors like those factors that I mentioned before, being the control mechanisms of close proximity in time and space, relationships and such, and reasonable fortitude are all just factors that go towards whether it's reasonably foreseeable that someone would suffer mental harm. So the Australian courts tradition have diverged from the English approach, and as I said, Bill will explain the Australian approach later in this presentation. So in the Paul appeals, you've probably had a chance to be looking at the facts while I've been talking. I will go over the facts briefly, but the point in that case, it was a conjoined appeal, all three similar with similar legal principles to be decided, and similar kind of facts were all joined together and efficiently dealt with by the Lords in one decision known as the Paul appeals. In all of those cases, the claimants asserted psychiatric illness, such as post-traumatic stress disorder, anxiety and depression. There was no challenge in those appeals to the requirement to show a medically recognisable psychiatric illness, nor as to whether that was met. And that's important, because the threshold requirement in all of these cases, which is not controversial, it's the same in UK as well as in Australia, is that the claimant has to show a recognised psychiatric illness. So that wasn't in dispute in the case, it was accepted. What happened, though, was the defendant actually brought applications to strike out all the claims on the basis that the claims could not succeed as a matter of law. So that's what the court then had to tease out, the legal principles in these cases. So, of course, you will have seen the facts as I've been talking, as I said. So in Paul, the claims were by the daughters of a fellow who had a heart attack and died in their presence, and his heart problems weren't diagnosed properly, and that was the medical negligence. Arguably, if he had been treated properly, he wouldn't have had that heart attack and wouldn't have died. In Polymer, what happened there was a young child had veno-occlusive disease. There was a negligence in the diagnosis of that disease, and she died, went away on a school trip, and when she came back, deteriorated really quickly and died in the presence of her parents. The parents brought the claim. So you can see that in these cases, all of the claimants are all the family members. In Paul and Polymer, the parents and the family members were there when the person passed away. In Purchase and Arnold, the mother of a 20-year-old daughter died from severe pneumonia, which developed to the extent that she passed away because of a negligent failure to diagnose. The difference between Paul and Polymer and Purchase and Ahmed was that the mother was horrific, was getting all these text messages and didn't, see the messages, and came in to find her daughter having just passed away, and then, you know, she saw that she had gotten all these text messages. So it was very much in the immediate aftermath, but there was no physical presence at the time. And, you know, that aftermath and physical presence has been a point of development in the law in terms of the control mechanisms. So the cases were all cases of medical negligence for the primary victim. All the people that were claiming for a recognised psychiatric injury were all family members, and they were all there at the time of the death, or basically straight away afterwards in the case of Purchase and Ahmed. So, as I said, the court had to deal with this question, you know, can these people recover, because it was a strikeout application. And the court, the approach that the court took was to first look at the case law about claims to mental harm broadly. And then they tested that by looking at the medical negligence case law, and ultimately, as I said, came to the conclusion that there was no recovery. So the first issue that the court looked at was, remembering I was talking about all these control mechanisms that the courts had developed, and you know, the reason was to work out a way of where the reasonable boundaries on recovery could be placed. So the court then said that here it was a bit different to the traditional cases where psychiatric injury claims by secondary victims had been brought. Because here it wasn't like McLaughlin, which was a road accident where the mother saw her family at the hospital in the immediate aftermath and developed a psychiatric illness. Alcock and Frost were the claims arising out of the Hillsborough Stadium disaster by ranges of various relatives who, some of them were there, some saw it on TV, a range of ways that they perceived the accident. But the point really that the court focused on was that all of those cases were accident cases, and they were categorised as accidents. The quote that I've put up there is, obviously the events weren't accidental in the sense that no one was to blame. They were caused by the defendant's negligence. In the stadium disaster, it was the police not doing proper crowd control. In McLaughlin, it was the motor vehicle driver. So they were accidental, but they were accidents in the sense that the definition that the court adopted was that there are unexpected and unintended events which caused injury by violent external means to a primary victim. So the secondary victim wasn't injured themselves or caught up in the actual accident. They were the passive observer. And then the court went on then to say, well, you know, are medical negligence cases accidents, or are they something else? And in line with the approach that the English courts have adopted, you know, adopting these artificial distinctions and categories to determine, you know, in, out, basically, the court said, oh, this is a majority, of course, said that here a medical negligence event is a medical crisis. It's not an accident. It's the suffering or death of the relative from illness. So, you know, the question then was, should accident be incrementally extended by the common law to include medical crisis? So here the courts are saying that there's a definition of accident. It's an external event which causes or has the potential to cause injury. And the court made it clear that it's the injury, it's not the injury, it's the actual external event that is the triggering mechanism for liability. So as I said, the question then became, you know, should it be extended to medical crises? So The court thought that no, they weren't prepared to extend their meaning of accident to include a medical crisis. The reasons that they found for this included a range of matters. So, for example, they said that an accident is a discrete event in the ordinary sense of the word. So it's something that happens at a particular point in time, at a particular place, in a particular way. So the benefit of that kind of thing is that it's allegedly certain. You can say if something's an accident or not, according to the court. By contrast, in non-accident cases, while the court acknowledged that it's not always true, there's often no discrete event comparable to an accident. So that was the first reason, a certainty reason, that an accident is something that you know what it is or not. Secondly, the court said that illness that's if a line is going to be drawn between cases where illness consequent on bereavement is compensable and cases where it's not, the court thought that distinguishing between claimants who actually suffered the ordeal of not allowing recovery of people who observed, it should be a reasonable place to draw the line. So if the reason for that is because people have different reactions to traumatic events, and it's difficult to evaluate how bad a reaction is. Another reason that the court thought that you shouldn't be extending this notion of accident to include medical crisis was that it's difficult to distinguish between primary and secondary victims. So if there's an actual accident, if the secondary victims in the vicinity, they might have a fear for their own safety in addition to the safety of their loved one. But if there's no actual accident, they don't have a fear for their own safety. So the court thought that that was another reason why you can reject medical crisis and only allow recovery for accidents. That then led the court to say that there might be an exception here in a medical negligence context, and that would be where the claimant was actually present during the the medical procedure that gave rise to the medical negligence. So examples of that could include, and the court said, well, look, we're not going to deal with this because it's not before us, it's for another day. But there is still a small window, at least in the UK. Examples might be where there's a negligent injury to a child during birth, or negligent injection of a drug to a patient where the doctor knows that the patient had a severe allergy, and the secondary victims kind of stand basically there in the room when this is going on. So there is that small window where there might be potential to extend this notion of accident to include a medical crisis. The other reason that was quite clear in the decision was that a defensive medicine argument, really, and that was that it was undesirable for decisions about end-of-life care to be complicated by the risk that if it's said that the death ought to have been prevented, the hospital is exposed to potential legal liability to family members who were there with the patient at their time of great suffering. So that was, the court refused to incrementally extend the law by allowing a medical crisis to be within this category of accident cases. Still left all those control factors in place. The other part of the reasoning was that they tested those general principles against the medical negligence cases in this context, and referred to the decision of Meadows against Khan. And the focus there was that doctors' duties are determined by the purposes for which the services are provided. So it's obviously the scope of any duty then is reflective of that. So Meadows and Khan, the court held that in that case, the purpose that the doctor was consulted was a risk of, in a particular risk in a pregnancy, that is giving birth. Sounds a bit like Jekyll and Hyde, doesn't it? The particular risk in pregnancy of giving birth to a child with haemophilia, and that was the risk that was it was concerning, and so the doctor could then not be liable for any unrelated risk, that is the child suffering autism. So in Paul, the court said that this idea of the purpose for which the services are provided is equally important to determine whether there's a duty for psychiatric harm for people other than patients. So the court really there was focusing on the idea that imposing such responsibilities on hospitals and doctors would go beyond what in the current state of our society is reasonably regarded as the nature and scope of their role. So the majority then returned to a central proposition that the general policy of the law is opposed to granting remedies to third parties for the effects of those injuries on other people. Focus is on primary victims, and the majority thought that it's not the narrowness of the category of eligible claimants which required justification, but actually the fact that secondary victims could recover at all. So you can see there's a really general resistance to recovery for secondary victims, and a real concern about containing the potential scope of liability. The majority in their conclusion said a line must be drawn somewhere to keep the liability of negligent actors for such secondary harm within reasonable bounds. So that's the reasoning of the majority. I'll just make a point about the dissenting judge and then hand over to Bill. The dissenting judge was Lord Burrows. So you'll know perhaps that Lord Burrows used to be an academic, and maybe he's still an academic, just on the court now. And he actually was the Law Reform Commissioner in the Law Reform Project, Liability for Psychiatric Illness, back in 1998. So you can see how long this has been going on in the UK for. The law, I think importantly, in the context of his judgment, I think it's important to note that, as I said, he led and he actually says it in his decision. I think I should declare that I was on the Law Reform Commission report. And he said, in that project, they recommended legislative reform in this area, that in addition to reasonable foreseeability of psychiatric illness to a person of reasonable fortitude, the requirement would be retained that the secondary victim must have a close tie of love and affection to the primary victim, therefore avoiding the floodgates. So the only control mechanism that the Reform Commission would be accepting of course, no one's really arguing with the reasonable fortitude, although in Australia it goes to reasonable foreseeability. But anyway, the family, or not even family, close ties of affection and love and affection was the control mechanism that the Law Reform Commission would be arguing for. So it wasn't surprising then that he was dissenting, because you can see his focus is really on a principled approach to the development of the law, and not having these arbitrary rules and tests that would just knock out liability. He said, Lord Burrows, that the correct approach was to reject that focus on accidents or events external to the primary victim and focus on the death as being the relevant event. And he thought that if you focused on the death, and if you come back to the facts in the cases, you can have a look at them again at your own leisure. I'm sure it'd be a fun activity this afternoon. He said that, you know, all of those control factors are satisfied in the context of the cases before the court if you looked at them from the perspective of the death being the controlling, being the relevant event rather than thinking in terms of accidents. So the Australian law arguably is more principled with the focus on reasonable foreseeability, but perhaps the problem with Australian law is certainty, and that's where we'll explain.
I'm not sure whether I can explain. I think it's fair to say that the decision in the UK Supreme Court at the beginning of this year came as a bit of a shock to most Australian lawyers who practice in this area. And from what I gather, talking to a few of the people in England, it came as a bit of a shock to some of the barristers over there as well, because there seemed to be a bit of a trend towards moving away from this idea of being at the scene of an accident. Yeah, the scene of an accident expectation in Australian law had sort of gradually disappeared, and it started, I suppose, disappearing, or maybe properly started disappearing around the time of the decisions of Tame and Annetts in about 2002. High Court cases, you might remember them. Annetts was a case where the son of some parents went missing on a country property and had died out in the wilderness and wasn't found until some time later, and they were able to bring a claim. And that sort of teased around the idea of whether you had to be there when someone died, which was the old sort of approach to the law. Tame was really just, I suppose, looked at the same time to consider the boundaries of the law. This was a strange case where Mrs. Tame had been given a infringement notice by a police officer for purportedly for driving under the influence of alcohol. She didn't drink alcohol. She didn't like alcohol. She, in fact, was very negative about the concept of alcohol. She obviously wasn't a lawyer or a law student, but she suffered a psychiatric injury as a result of that false accusation. And that enabled the court to sort of look at that idea of saying, well, you know, do we really want the law to go that far, where we have people who have some particular fragility, some vulnerability, not in the sort of old eggshell skull way, but something going beyond that perhaps. But in any event, it enabled the court to go through the principles. And on the slides, which I think will be made available afterwards, if that's possible, there are some quotes from some of the judges in the Tame decision. So Chief Justice Gleeson talked about the earlier idea of proximity and said that that had pretty much, I use the phrase, had gone out of fashion, but he more politely says it had not served as a unifying doctrine. It didn't work as well as they wanted it to, so that the relationships in that sense weren't necessarily the entire answer. Justice Gaudron made a sort of more robust statement in saying that the common law of Australia does not and should not limit liability for damages for psychiatric injury to cases where there was a sudden shock, which is sort of like the accident idea. You know, you're at the accident scene. And I know being at the scene of an accident, a sudden shock are not necessarily the same thing, but there are some parallels there. And she said also it wasn't necessary for a plaintiff under Australian law to have directly perceived a distressing phenomenon or its immediate aftermath. And that really opened up the possibility for family members or close family members to bring claims even though they weren't at the scene, either of an accident or of a death. They could have just found out about the death a little bit later on. Gummo and Kirby made a comment about temporal or geographic connection and said that they didn't really like that idea as a control mechanism because it tended to produce, as they called it, arbitrary outcomes and to exclude claims that might have been meritorious. So in Australia since 2002, we'd had that sort of approach to mental harm claims. And it reminded me when we were looking at this, at the sort of disconnect that existed between England for a while when we had Rogers and Whittaker since 1992, and they didn't get around to a similar consideration of failure to warn claims until McCulloch almost 20 years later, when they sort of caught up with the Australian law in that sense. If you actually look though, I mean, having said that and having, I suppose I've made it sound as though I'm saying, well, there's nothing to see here. What are the English courts talking about? There hasn't really been a great deal of scrutiny on this issue. There has not been a case like the Paul decision that's gone all the way to the High Court to tease out the scenario of mental harm following medical treatment. There have been some cases, and there have been a couple that have got to the appellate level. They sort of assumed up to a point that the cases were available. There was a New South Wales Supreme Court case, Court of Appeal case in 2007 called, and pardon me for my Greek pronunciation, Panagiotopoulos and Regendrum. Sorry, Tina. That was a scenario where Mrs. Panagiotopoulos had been a patient of Dr. Regendrum. There was a delayed diagnosis of colorectal cancer. She ultimately died, and the husband was able to, or the husband brought a claim for mental harm as a result of her death. It doesn't even necessarily focus on whether he was there at the time she died, but let's assume that he was. And what Justice Baston and Tobias and McColl, all very strong common law judges in the Court of Appeal in New South Wales, said about that was, well, the first step is to identify the nature of the duty in a broad sense, and then said the existence of such a duty may be readily assumed. And that was it. So there was not the sort of analysis that we've now seen in Paul, where the court's sort of saying, well, we're going to deal with accidents over here and medical cases over here. There was none of that. And that is the Court of Appeal decision. That's it in terms of appellate authority. Nothing gets up to the High Court that helps us sort of put some more of a gloss on that. There were a couple of other decisions, some first instance, but they all tended to assume that the duty existed. Now, of course, when the UK Supreme Court were looking at the decision in Paul, they commented on whether they had been, I think they had a bit of a slight, how can I put it? They had a bit of a slight dig at the council for not giving them information about overseas cases and authority. But what they said was, well, that may be fair enough because Australia's got that newfangled Civil Liability Act idea, and we don't really understand that, and it's all different in the different jurisdictions in any event. But what it does do, and there are slight differences between the jurisdictions, but if you look at New South Wales, the focus there in section 32 of the Act, and you'll see this reference to when a duty of care is not owed, and the elements that have been written into the Act is firstly foreseeability, which is something which, even though he was in the minority, Lord Burrows said, yeah, we can't go there, it's all too radical. Well, I've got news for Lord Burrows. We've had it for a fair while now. Foreseen that a person of normal fortitude might, look at the words, in the circumstances of the case, suffer a recognised psychiatric illness, so more than a mere grief reaction. And then that seems to be the statement of principle. There are some little elements that are written in subsection 2, which I suppose are put there for the guidance of judges or the courts, where they say, well, the factors might include sudden shock, but that's not essential. The plaintiff might have witnessed at the scene the person being killed or injured, but that's not essential either. There's the nature of the relationship. Now, when Peter Hanford was writing about this area in about 2016, he focused on the relationship aspect. And then there's this idea of a pre-existing relationship, between the plaintiff and the defendant, which might be of particular relevance in a medical treatment scenario. Although, you know, obviously one step removed. So I wonder whether in some ways, Peter Hanford's comment about nature of relationship now just gets wrapped up into this idea of circumstances of the case. And if that's right, all we really have is foreseeability, normal fortitude. The person has to have normal fortitude, not like Mrs. Tame, who got such an adverse reaction from getting a ticket from the police officer, and then recognised psychiatric illness, so there was a sufficiently severe outcome. Now, there are some other provisions which I won't spend a lot of time on, but yeah, there is a little bit more detail in the New South Wales Act. There are definitions of close family member, which helps a little bit when you're trying to pin down exactly who has that sort of relationship. Section 72, I think, is the Victorian equivalent in the Wrongs Act, but it's pretty much the same when you're talking about normal fortitude, circumstances of the case, recognised psychiatric illness. There were some other cases after the Civil Liability Act came in, but again, when we look at them, and this is only a first instance decision in the New South Wales District Court, which is a county court equivalent, nothing really is focusing on whether or not there was a duty there in the first place. So having said that about the New South Wales or the Australian law, I guess the question is perhaps this, in the 3 minutes we've got left, is the audience participation part of the program. Is it simply the case that, you know, the minority approach in the Paul decision was right? Or are we really in a position where we've just drifted along for a while in Australia, where lawyers running these sorts of cases haven't really thought too much about the duty question and whether or not there is a problem similar to Paul, not necessarily in all scenarios, and I suspect not really in medical treatment scenarios, but one area where it may be coming up for the attention of the courts is in the abuse area. And I say that for this reason. It is now well recognised that if you've got someone who is a victim of child sexual abuse, they can bring a claim against a perpetrator and sometimes against an institution. There's no difficulty in that. And you would imagine there would also be no difficulty in if I, as a parent, had a child and I discovered, you know, that last week they were sexually assaulted at school. They may well have been injured physically and emotionally. That's a secondary victim claim, but it seems to fit within the scenario that we've been talking about that's been established in the Tame and Annette's decisions and picked up by Section 32 of the Civil Liability Act, 72 of the Wrongs Act. Foreseeability, normal fortitude, relationship, circumstances of the case. But what if you go further back? What about a scenario where the victim is someone who was assaulted as a child, but then many years later, they meet someone and they marry. And they, at some point along the way, develop, as sometimes happen with these sorts of problems, a psychiatric illness. You know, they might even attempt suicide. And let's assume, to exaggerate the point, to make the example, that they succeed in suicide. Can their spouse bring a claim for mental harm? Now, think about that phrase, circumstances of the case. Certainly, they're within the sort of circle of close family member now, but they weren't at the time the tort was committed. And I do wonder whether in that sort of scenario, the courts might say, well, that's a bridge too far because we've got a tort over here and we've got quite a disconnected tort event or injury sometime down the track. But then you might say, well, you could have the same thing in medical treatment. You could have a delayed diagnosis of cancer. It might be years before someone realises they have untreatable cancer. Why is it different? And then the third one is the position of a child. So again, you've got a person who as a child is sexually assaulted at a school. They grow up. They get married. They have children of their own. And then let's assume again that their mental health deteriorates for whatever reason associated with the abuse and they commit suicide. Can that child bring a claim? They're a close family member now, but if you look at the circumstances of the case, they weren't even born at the time the original tort was committed.
Okay, thank
Oh,
you.
right.
All right, we're right at time, but thanks to Bill and Tina for the offer to stay afterwards if people have questions to bring to them. Just a very big thank you to both of you for introducing the group to this case and for your sharing your analysis of it. And it's obviously something for us to watch as the law keeps developing in this area. And thanks to everybody for joining today. Bill is teaching medical litigation at the moment, as I mentioned. There'll be another iteration of the subject later in the year. If anyone who's not doing the subject would like the chance to do it with Bill in October. And the law school welcomes single subject enrolment. You don't have to undertake the full Melbourne Law Masters to be able to do Bill's subject amongst others. So thank you everyone for joining us. Thanks to everybody online. And we look forward to seeing you at the next Helen seminar. Thank you.